Welcome, everybody, and Happy New Year. I'm Deborah Satz, and I'm an instructor for this class along with Paul Brest. I'm also a philosophy professor, and Paul is an emeritus law professor. This is our third time teaching the class, and Gabe Malik and Kesa Goodman serve as our teaching assistants and course fellows. We also have section leaders for those who've enrolled for an extra unit. So if you haven't enrolled for 2 units and you're interested in participating in the practice of democratic dialogue, consider signing up for a second unit. So let me just say what the course is about and give you a big overview. Deep disagreement pervades our democracy, from debates over immigration, taxation, foreign policy, including recent activities in Venezuela, the Middle East, to the function of very selective institutions of higher education like Stanford and the value of free speech itself. Such disagreement is not by itself a cause for concern. We should expect that in a democratic society, one not ruled by a king or an autocrat, that is, a society based on the equal freedom and equal status of its members, reasonable people will disagree about many things. Some of the deepest questions of morality, religion, and value are hard to think through. Even people who are well-motivated and conscientious will answer questions pertaining to these matters in different ways, perhaps because of their different life experiences, or because the facts are hard to pin down and admit of various interpretations, or because they'll make trade-offs, different trade-offs among competing values. The same is true of more mundane issues of policy. In other words, disagreement is a feature of a democratic society and not a bug. But not all disagreement is productive or reasonable. Sometimes people fail to consider inconvenient facts and close their minds to evidence and reasoning that doesn't support their favored view. Facts can actually rule out certain views or make holding them onto them very costly. In addition, and very frequently in online platforms, a culture of incivility prevails, with respect to those with whom we disagree. Note that by incivility, I'm not talking about politeness. I'm talking about the failure to treat other people with respect simply because they hold different views about issues that we care about. This uncivil closing of the mind is especially a concern for a university. The fundamental mission of a university is the pursuit of knowledge, and the pursuit of knowledge absolutely depends on the free exchange of ideas and an openness to question received opinions. History shows us how often we get things wrong, how vulnerable we are to narrow-minded provincialism, even when we're trying to figure out the truth. And John Stuart Mill reminds us in On Liberty of the cases of Socrates and Jesus, the first executed for impiety and immorality, the second executed for blasphemy. The human race is capable of monumental error. So we need to keep open minds. It's because we feel this mission, the pursuit of knowledge, is under stress from forces both outside and inside the university that Paul and I decided to launch this class, which is now in its 3rd iteration. Furthermore, in addition to thinking it's not good for the university for there to be closed minds, we believe that closed minds are also not good for democracy, and that universities have a role to play in producing responsible citizens. But you should feel free to disagree that that's an appropriate role for the university. As we note on the syllabus, the course is offered in the spirit of the observation by Hannah Gray, the former president of the University of Chicago, that education should not be intended to make people comfortable. It's meant to make them think. Each week features scholars who disagree, sometimes quite strongly, about major policy issues. But each is committed to follow the evidence and to try to present reasons that others can understand and acknowledge. Each class is focused on a different topic and has guest speakers presenting for about 10 to 12 minutes each, and then we participate together in a conversation on stage. Paul and I will take turns serving as moderators. This year's topics include today's topic on this related to the scope of presidential power. It includes Israel-Palestine, which is next week's topic, policies during COVID, gender-affirming care, internet regulation, and the war in Ukraine and fetal personhood. So lots of topics about which there are strong views and lots to understand about the bases of disagreement. After the first hour or so, the floor is open for questions and comments from the audience. We also will survey you at the beginning and the end of each class. There'll be a question because we're interested in whether or not arguments move minds. It's not necessary that your mind is moved, but we're curious as to whether your mind is moved by anything that you hear. And we hope, even if your mind is not moved, the class gives you a better understanding for the reasoning behind the views that you reject. Productive disagreement, reasonable disagreement, is actually quite hard. In addition to having an open mind and being able to listen to others, it requires knowledge of facts and values at stake in an issue. We hope that the course engages you in all these ways and deepens your appreciation for the complexity around these very important issues that are so important to our future. And with that, I will turn it over to Paul, who will introduce today's speakers. Thanks.
Let me add my welcome to Deborah's. How many of you are enrolled in College 102 and Citizenship in the 21st Century? Quite a few, that's great. From time to time, it may be useful to connect the two courses, and I'll just make a very brief connection here. For the first week's reading, we looked at an article by Anne Applebaum titled, "Democracies Don't Try to Make Everyone Agree." And as Deborah just mentioned, disagreement in a democracy is a feature, not a bug. And I think you'll find that beginning today and for the rest of the quarter, disagreement will not be a problem in this course. One housekeeping matter, Deborah introduced our two TAs who are in back, Kaisa Goodman and Gabe Malik. If you are intending to take the 2-unit discussion seminar and haven't received an email about it, then after the class, go talk. Is it Kaisa they should talk to Gabe? Talk to Gabe about it. So now let me introduce our two guests. Brian Fletcher graduated summa cum laude from Harvard Law School, where he served as president of the Harvard Law Review. He began his legal career clerking for Justice Ruth Bader Ginsburg and then Judge Merrick Garland. And Professor Fletcher is an experienced appellate lawyer who specializes in representing clients before the Supreme Court, where he's argued 22 cases. In addition to several years of private practice, he served as associate counsel to the president, counsel to the attorney general, and special counsel to the Federal Trade Commission. Professor Fletcher is co-director of the law school's Supreme Court Litigation Clinic. He was that from 2019 to 2021. And now he's back at Stanford after serving as the principal deputy solicitor of the United States. So here he is back. Sai Krishna, or Sai Prakash, holds 2 named professorships at the University of Virginia Law School, where his scholarship focuses on separation of powers, particularly executive power. Professor Prakash majored in economics and political science here at Stanford, and then attended Yale Law School, where he was an senior editor of the Yale Law Journal. He subsequently clerked for Judge Lawrence Silberman of the U.S. Court of Appeals for the District of Columbia, and then Judge Clarence Thomas of the U.S. Supreme Court. After practicing for a couple of years, he entered academia. In addition to many law review articles, he's the author of two important books, and I'm going to mention a third: Imperial from the Beginning, The Constitution of the Original Executive, and then recently, The Living Presidency, an originalist argument against its ever-expanding powers. That was published by the Harvard Belknap Press in 2020. And he brought with him a book that is going to be available, in fact, it's available on Amazon right now, called The Presidential Pardon. And as you probably know, the issue of pardons has been much in the air, with some controversial pardons by President Biden and now some controversial pardons by President Trump. And I expect you will find this a very timely book. So, to quote the background article assigned for today, few constitutional issues have been as significant in the first 100 years of the second Trump administration as the question of whether the president may fire heads of agencies subject to statutory protection from removal. The underlying issue, whether Article 2 confers on the president the power to remove executive subordinates that Congress cannot take away, has a claim to being one of the oldest constitutional debates in American law. Our two guests will discuss these issues. While reference to the original meaning of the Constitution is inevitable, they'll focus on policy issues and the implication of this question 2 centuries after the founding and situated in the broader question of the theory of the unitary executive. Professor Prakash will lead off, talking for about 10 minutes. Professor Fletcher will follow, and then I'll moderate the conversation for the remainder of the first hour before opening it up to your questions. Before we begin, and can we put the polling question up there? Before we begin, use your phones to answer the polling question. We'll ask the same question at the end of the conversation. And now, on to Professor Prakash.
Well, it's a thrill and an honor to be here with you today. I was an undergraduate here and a ne'er-do-well at the Leland Stanford Junior University, and I would have been in the back row way back there, even further back than some of the people back there. When I was a student here, I thought about majoring in computer science, and I thought that will never lead anywhere. And so I studied political science and economics instead. And so instead of being a billionaire, I'm a law professor, and I really love my life and my job. And as you can tell, I'm the person on the left here. Right? I'm that person up there. So I'm tickled to be here today. I want to give you 3 reasons why I think the president should be able to fire the heads of these executive departments. 1 sounds in law, 1 sounds in policy, and 1 sounds on the assignment of responsibility. And we were told not to dwell on the law too much, but of course I'm a lawyer, so I will say some things. The Constitution, as you know, separates 3 different powers across 3 different branches. Congress has legislative power, the president has executive power, and the courts wield judicial power. And what does that mean? Well, Congress is supposed to make the laws, the president is supposed to execute those laws, and the courts are supposed to adjudicate disputes about the meaning of those laws. And when the Constitution assigns the president the executive power, I think the Constitution gives the president the powers that were long associated with executives at the state level and at the national level prior to the Constitution, and in other countries like England and France that would have been examples to the founders. The Constitution doesn't say that the president can remove. The only time removal is mentioned in the Constitution is in impeachment, but I think very few, if anyone, thinks that impeachment is the only way to remove an officer. There were people who thought this in 1789, I think 1 or 2 people in the Congress, and it never had any traction because they thought that the executive branch should be responsible. And the question is, responsible to whom and in what way? I have the position of James Madison. I proudly have it. He said in 1789, I conceive that if any power whatsoever is in its nature executive, it is the power of appointing, overseeing, and controlling those who execute the law. And that's what he said in a debate in Congress about whether the Constitution granted the president the power to remove and whether Congress ought to recognize that in some way. I believe that Congress did enact statutes that recognize the president's power to remove. And then when you turn to the first president, Washington had the same view. He said, quote, the impossibility that one man should be able to perform all the great business of state, I take to have been the reason for instituting the great departments. What does that mean? We have these departments because the president has powers that he cannot exercise without the assistance of others. Because he cannot, in particular, go out and execute all the laws on his own. He needs tax collectors. He needs prosecutors. He needs a military to help carry out congressional statutes related to the conduct of war in the military. And so when you look at the first Washington administration, Washington is a chief executive. He is directing prosecutors. He is directing tax collectors. He is meeting with his cabinet and giving them instructions on almost a daily basis. He's basically superintending the executive branch, as I believe the Constitution meant to establish. And so this practice of the president sort of running the executive branch dates back to the 18th century, dates back to a particular reading of the Constitution. That's the legal portion of my remarks. I'm happy to say more in questions. What about policy? Why did they want this? Why is it a good idea? There's always a policy reason behind a structure, right? They're not randomly picking a structure. The founders sought to create an energetic executive. They had seen the issues with a weak executive. They had seen a weak executive in two different places. One is at the national level. At the national level, there is no separate executive. The Continental Congress is a plural executive. The Continental Congress creates departments under its superintendents, but Congress is not always in session. The members of Congress don't stay in Congress very long, and so there's very little supervision of what the departments are doing. They don't like the chaos that comes from a plural executive that's only in being for part of the year. At the state level, the state governors and the state executives are rather weak. Most of them don't have a veto. A lot of them are stripped of their appointment powers. And a lot of them are plural, meaning that it's a plural executive, an executive council that wields whatever authority is vested in the state executive. And then finally, many executives are subject explicitly under the state constitutions to state legislative regulation, meaning that the state legislatures can tell them how not to or how to exercise the powers that the state constitutions convey them. They look at that and they say these state executives are ciphers. They're non-entities. They don't have any real power, and law execution is suffering. They believe that they need to create an energetic executive to make sure that congressional resolves related to tax, spending, commerce, the military are carried into execution, right? Because executing the law is the principal task of an executive, as the name suggests. So that's why they, in my view, create an executive charged with superintending law execution and giving directions to officers and being able to fire them. And there's kind of I think, a unanimity on the point that the president will be responsible for execution. Governor Edmund Randolph says, the superior dispatch, secrecy, and energy made it more politic to vest the power of executing the law in one man. Richard Henry Lee opposed the Constitution, but he admitted that the single executive at the apex of the executive branch was, quote, well circumstanced to superintend the execution of laws with discernment and decision, with promptitude and uniformity. Right? They both thought that the president would be superintending the executive branch because he has the executive power, not the Secretary of State, not the Secretary of Defense, not the Secretary of Interior. When he was president, Thomas Jefferson described the practices of the Washington administration, of which he was the Secretary of State. And he said, Washington, as president, formed a central point for the different agencies, preserved a unity of object and action amongst them, and exercised that participation in the suggestion of affairs which his office made incumbent upon him, and met himself with due responsibility for whatever was done. What is he saying? He's saying Washington was at the center of a wheel. There were spokes, there were people doing other things, but they checked in with Washington to make sure that he agreed with what they were doing. And in fact, he describes Washington going over their correspondence, right? He had that much involvement in the affairs of the department. And there was one letter from Washington where he says, everybody left town, I am handling all the departmental business myself. There's no statutory warrant for the president to do that. There's no statutory warrant for him to be able to direct and remove all these people. He's doing this because by this time there's a consensus that he has the authority to do so under the Constitution. That the Constitution, by granting him the executive power, the power over law execution, and the power over officers that enforce the law, that he can do these things, right? He doesn't need a statute. He's got the constitutional warrant. So that was policy. They think it's better law execution if you have one person superintending the executive bureaucracy. Let me now talk about responsibility. The founders believed that if you concentrated executive power, you could better hold the person accountable, both politically and legally. Why did they think this? Because they saw the example in state constitutions of having a plural executive. When you have a plural executive, it's possible you come to no conclusions, and it's possible that even when you come to a conclusion, people then disagree as to why the particular conclusion was reached, right? The buck stops in 7 different places, right? To quote Harry S. Truman, right? We don't know who's responsible because there's many voices. They thought if you concentrated power, it made it easier when it came to law execution to figure out who to blame. If you don't like the immigration policy, you can blame Joe Biden. If you don't like the immigration policy now, you can blame Donald Trump. If you don't like the marijuana enforcement policy, you blame Joe Biden. If you don't like whatever Donald Trump is doing with respect to law execution today, you can blame Donald Trump. It's far easier to assign responsibility to one person than it is to assign responsibility to a multitude. They thought that. That wasn't the only desiderata of a political system, right? They thought that lawmaking required many minds and deliberation, but they thought executive authority required swifter, more decisive action, and they thought it was more conducive to responsibility. So that's why they created the system. Now, I happen to grow up in the Golden State. That's this state, right? The Golden State. I think it's still called that. I grew up in San Diego. California does not have a unitary executive. It has a plural executive. I think the voters of California vote for 7 different people. And I wrote this down. The governor, a secretary of state, a superintendent of public instruction, a state controller, a state treasurer, an attorney general, and an insurance commissioner. Many Americans do not know who the vice president is. I don't know how they're going to know who the state insurance commissioner is. I'm not from California. I've had to look it up. How many people are here from California? Do you know who your state insurance commissioner is? Maybe you do. You're at Stanford. God bless you. It's Ricardo Lara, right? I don't know anything about. I looked him up on Wikipedia. There is a web page. But the point is, if Gavin Newsom was in charge of executing California's insurance laws, whatever they are, you could blame Gavin Newsom, right? And he could appoint Richard Lara and be held responsible for what Richard Lara does. That, to me, makes a lot more sense than trying to figure out, who the insurance commissioner is and then trying to hold them responsible. So let me end with 2 final thoughts. I have 3 thoughts. One thought is, this is unfair because Brian's a Supreme Court advocate. He's argued 22 cases before the Supreme Court. That is 22 more than me. Right, that's 22 more than me. And it's only going to get worse, right? So let me end with 2 final thoughts. This is not about war powers. This is not about foreign affairs. This is about law execution. The claim that the president gets to direct and fire people is principally about law execution. It doesn't follow that the president can take us to war in Venezuela. It doesn't follow that the president has immunity. Those aren't entailments of anything I'm claiming today. I don't believe those things, but I do believe this. So don't confuse what I'm saying with the view that the president can just do whatever he wants. This is about directing and firing people as they execute the law. It is possible that his directions will be illegal, just like it's possible that the people who couldn't otherwise be fired by the president could do something illegal, right? You can have illegality with strong presidential control of the departments or without it. So it's indifferent to that. And then let me say finally, this is not about President Trump. I had this view under Ronald Reagan. I had it under Bill Clinton. I had it under Obama. I had it under Trump. I had it under Biden. I have it now. I'm not wrong because you may think Donald Trump's a devil, and I'm not right if you think Donald Trump is the second coming of whoever. So thank you so much, and I look forward to hearing what Brian has to say.
So that was wonderful. Thank you so much, Sai. Thank you to Deborah and Paul for the opportunity to be here. Believe it or not, I was actually going to start with some sandbagging of my own by telling you that I, unlike Sai, am not a scholar of presidential power. I am but a mere humble litigator. I have published no books and no law review articles on the subject. But no, in seriousness, I do think it's helpful to put on the table how I come at these issues and why, because that may help you and my colleagues here in the discussion understand what's led me to the perspective that I have. And my experience with these issues has been primarily as a litigator, not as a scholar. In the government and at Stanford, I have been involved in cases raising questions about the president's removal power, and it's been almost exclusively in defending statutes that limit that power against challenges that are based on the sort of unitary executive type theory that you just heard Sai sketch. So I don't pretend to have a fully thought through theory of my own about how the Constitution works, but what I think I can do is give you a sort of defense of the conventional understanding of the president's power and Congress's power in this space that was the prevailing understanding of where the law stood before the Supreme Court started revisiting these issues, let's call it 10 to 15 years ago. This is the theory on which the laws that are currently at issue in the Supreme Court were based, I think, although Sai can correct me if he has a different view. So how does that view differ from the one that you just heard, that the president has to be able to fire everybody who leads an executive branch agency at will? Well, actually, I think it's helpful to start with the areas where there's agreement, where there's not divergence. So I think I agree with Sai that the power to remove the heads of executive branch agencies is an executive power in the sense that it's a power that has to be in the executive branch. Congress can't give itself a role in deciding whether or not to fire the Secretary of State or the Secretary of Defense, right? It wouldn't be insane to have a system where that's how things work. That's a parliamentary system, but as Sai said, that's not our system. In our system, we separate Congress from the execution of the laws, and we don't think Congress should have a role in controlling the people who execute the laws. And the ability to fire a person is obviously a very, very powerful tool for control. So I don't disagree that Congress can't give itself a role in deciding whether the Secretary of State stays the Secretary of the State. Our disagreement is instead about whether and to what extent can Congress regulate the circumstances under which the president can remove subordinate officials. In answering that question, I think there's probably a second area of agreement, which is that the president's authority to remove and his other mechanisms of control have to be enough to allow the president to fulfill his or her constitutional responsibilities. That sounds pretty abstract and maybe like a truism, so let me make it concrete in two ways that are relevant here. One is, I think there are some officers who the president basically has to have complete control over. So the classic examples are the Secretary of State and the Secretary of Defense. These are people who are charged with helping the president carry out his own constitutional responsibilities over the military and over foreign affairs. They basically have to be, in order for the president to fulfill those responsibilities, able to act as the president's alter egos. The president shouldn't be stuck with a Secretary of State who doesn't have his complete confidence, his complete trust, or who disagrees with him on how the nation's foreign affairs ought to be conducted. And second, the president has a more general duty under our Constitution to take care that the laws be faithfully executed. And so whatever restrictions Congress puts on the president's ability to remove anybody in the executive branch, I accept, have to leave room for the president to remove somebody who's not faithfully executing the laws. Okay, so that's a lot of agreement. Where do we disagree? I think it's this. In my view, subject to those two important constraints, the Congress's ability and authority to create administrative agencies and to determine how the administrative state is structured includes the authority to limit the circumstances under which the president can remove some officials. And the traditional formulation is to say that the president can remove someone only for inefficiency, neglect of duty, or malfeasance in office. That's a standard, you'll notice, that gives the president the ability to remove somebody who's not faithfully executing the laws, but has traditionally been understood not to allow a removal over just a policy disagreement, or to allow the president to boot somebody out because he doesn't like someone and would rather have somebody else in the job. So my legal disagreement with Tsai, I think, is that I think in some circumstances Congress can impose those limitations. And in policy terms, I think there are some circumstances, maybe not every circumstance, because there's a lot to be said for the virtues of accountability and sort of energy and the unitary executive sense that Tsai just described. But I think there are some circumstances that we'll talk about in a minute where there are really compelling reasons for Congress to decide that officers performing particular functions ought to have a little bit of insulation from the president and from politics. Okay, I want to sort of build that out with 3 points. And the first one is talking about Congress's authority in this area. I think a remarkable thing about our Constitution is that the structural provisions allocating authority between the President and Congress haven't changed much since the Constitution was written in 1787, but the world has changed enormously, right? We've lived through the Civil War, the Industrial Revolution, the Great Depression, the Internet age, and the executive branch has exploded from something like a few hundred people into millions and millions of people who are doing all sorts of things that the framers, I think, probably couldn't even have imagined. The author Michael Lewis has written a couple of books that I'm grossly oversimplifying, but basically his theory is you could sort of throw a dart at the organizational chart for the federal government and find somebody who's doing something interesting and important that you have never heard of and have no idea about. And that may be a little bit of an overstatement, but the federal government and executive branch agencies are doing just huge numbers of things that they weren't doing 200 years ago and that James Madison and George Washington probably couldn't even have imagined. And how is it that our Constitution has been flexible and resilient enough to allow for all that change? Well, the answer is that the framers were wise enough not to try to spell everything out in advance. The Constitution doesn't say there will be a State Department and a Treasury Department and a Defense Department and nothing else. It writes in very broad terms. It gives powers to Congress to regulate commerce, to spend for the general welfare. It says the president, the executive power lies with the president, and he shall take care that the laws be faithfully executed. And then it doesn't say much else. It leaves a lot of room for the political branches to adapt the structure of government to the changing needs of society. And the primary vehicle through which it does that is something called the Necessary and Proper Clause, which says Congress has the authority to make all laws that shall be necessary and proper for carrying into execution Congress's own powers and also all of the powers that are vested in any other entity in the federal government, including the president. And all of the administrative agencies that we know today are creatures of the Necessary and Proper Clause. Congress has decided that it has the authority to regulate interstate commerce, and so there should be a Securities and Exchange Commission and an Interstate Commerce Commission, all of these agencies that exercise that authority. And Congress has decided what authorities they should have to make rules or to bring enforcement suits, to resolve disputes, who should staff these agencies, what their budget should be. All of those things are done by Congress. And my view is that Congress's authority to create these agencies, to staff them, to give them powers, also includes the ability to prescribe the circumstances under which the president can remove the people who lead them. The second point I want to make is one about history, because I think, and this is, I suspect, another point of agreement, in separation of powers questions, history matters a lot, and the way that the branches have actually worked out and implemented those very general provisions of the Constitution sheds light on what those provisions mean. And here, as you read in the readings for the class and as Tsai alluded to, this has been a debate between the branches since the founding. When the very first Congress was setting up the very first departments, it had an enormous debate. There were a range of views, and that Congress decided that for the Department of State, the Department of Treasury, and the Department of Defense, the president, rather than the Senate, should have the authority to remove the heads of those departments. But Congress didn't think at that point in time about other agencies that look very different because those other agencies didn't exist yet. And Congress also didn't think at that time, because no one was proposing it, about laws that said that the president can remove executive officials, but can do so only if he has a good reason for doing it. Congress first confronted those questions much later, I think in 1887, when it first created the Interstate Commerce Commission, the first modern regulatory agency. And when Congress did that, it decided that that agency should be headed by 5 commissioners who were going to set the rates for interstate railroads, which was a hugely important part of the economy at the time. And to provide a little bit of insulation and stability in the rate regulation, Congress said that those commissioners should be removable by the president only for inefficiency, neglect of duty, or malfeasance in office, that typical formulation. And as the government got bigger and more agencies joined the ICC, Congress replicated that structure. It did it with the Federal Reserve in 1912, with the Federal Trade Commission in 1914, and with some 2 or 3 dozen other agencies over the next 100 years. Something like 15 different presidents have signed legislation creating agencies that have that sort of protection from removal. And they have now become, I think it's safe to say, a real part of the fabric of our government. And I think that that sheds light on how we ought to understand the provisions of the Constitution. Now, you might say, why? If I'm wrong about all that, if that's unwise, or if that's against the Constitution, then shouldn't we stop doing it? And why should the fact that we've been doing it for a long time be a reason to keep doing it? And I take that point, but I guess I think in part as a measure of humility, we should be reluctant to say, based on in specific or generally worded provisions of the Constitution, that something that's been going on for 100 years or more is unconstitutional, is out of bounds. And I also think it'd be enormously disruptive to change things at this late date, because Congress has given a lot of authority to these agencies on the understanding that these agencies aren't subject to at-will removal by the president. And you can't take that back, right? If you decide tomorrow that actually these agencies do serve at the pleasure of the president, then that's really changing the nature of what Congress did. It didn't give that authority to people who are insulated from politics by these removal protections. It's instead given that power to the president, and there's no easy way for Congress to come back and re-examine all of those delegations of power that have been made over the last 100 years or more. So the last thing I'll say, I think we'll shift over into policy, and we'll talk about sort of why is it that sometimes Congress might decide that it's a good idea, despite the virtues of accountability and sort of energy and a unitary executive that Cy talked about, to have some insulation between the president and people who are executing the laws. And I'll give you just a few examples. So one are circumstances where the president might have a conflict of interest. So the Federal Reserve sets interest rates. I am not an economist. I apologize to those of you who are. I may be butchering this, but roughly speaking, when the Federal Reserve lowers interest rates, that encourages economic growth, and that's a good thing. On the other hand, it risks inflation in the longer term. And there's a concern that if the president had total control over where interest rates were set, there'd be a huge incentive to goose interest rates just before the election so that the economy looks great, even though the result might be that over the long term, we have more inflation than we otherwise would. Or at least there'd be a fear that people would perceive that that's what was going on. And so since its inception in 1912, the Federal Reserve has had some protection from at-will removal. The Federal Election Commission, which enforces election laws and regulates political candidates, including the president when he's running for re-election, I think is another case where there's a very clear conflict of interest question like this. A second category are cases where the rights of individuals are at stake. So the Merit Systems Protection Board is the entity within the executive branch that enforces the civil service laws, the laws that say you're not supposed to be fired for your politics if you're a junior employee in the federal government. You have certain civil service rights. That's a big part of our system, and it's enforced if you're an employee and you think you've been fired wrongly. You are not able to go directly to an Article III court. You have to start off in an administrative agency called the MSPB. Whose whole job is to enforce the civil service laws and keep politics out of civil service hiring and firing. Again, I think it's pretty obvious why Congress decided that the members of the MSPB shouldn't be subject to at-will removal by the president and should instead have some insulation from the president's at-will removal authority. So those are just a couple of examples. There are others, circumstances like the ICC, where Congress has decided that there's a good reason to have some stability and to not have radical changes in what an agency is doing from one administration of a president to another. But I think those give an indication of why, over the last 100 years, as the government has gotten more and more complicated, as agencies have done more and more things, Congress has sometimes decided that the sensible way to structure a particular agency because of its particular functions is to give it a little bit of insulation from the president. In my view, that's a valid exercise of Congress's authority to structure and adapt the executive branch, and it's not an infringement on the president's constitutional authorities because he retains the authority to remove officers if they're failing to faithfully execute the laws. Thanks very much.
Why don't the two of you engage in the conversation you would have even if you didn't have 150 people out there?
Well, that was wonderful, Brian. There's a range of views on the other side. Some people would say the president doesn't have a removal power at all, and therefore it's obviously no problem for Congress to give him a power and to constrain it, but that doesn't seem to be Brian's position. Another position would be they can impose removal restrictions on anybody. That doesn't seem to be Brian's position either. His position seems to be that where the Constitution requires that the president have an unrestricted removal power, then the president has an unrestricted removal power. And I agree with the claim, it's just that we have a different set. Brian wants to say the Secretary of Defense and the Secretary of State are different. If you read the Constitution, Congress has plenty of power over both. The president can't create an army or a navy. The president cannot create uniform code of military justice or what they used to call articles of war. The president can't fund the army and the navy. The president can't make treaties. At least he couldn't before the modern Constitution, where it happens quite often, right? So there's all kinds of congressional authority over foreign affairs, foreign commerce, for instance, declaring war. There's all kinds of authority over the military. I don't believe that's a defensible line, but Brian has good company because I think Justice Kagan said something very similar, but I don't think she defended it. It was an intuition that the president should be able to control these officers and that they're somehow different than the Department of Justice or the Department of Commerce. I know that's her intuition, but what's the constitutional basis for it? I don't see one. People don't realize this, but George Washington was commander-in-chief before he was commander-in-chief. He could not fire anybody as commander-in-chief under the Articles of Confederation. He only had that authority when Congress gave it to him. So the authority to be a commander-in-chief does not come subsumed with the authority to fire. And so I think that the line that Brian is drawing is eminently reasonable. We can imagine a world where we think the president ought to have authority to remove certain people and not others. But I don't think the Constitution itself draws that line. The other thing I would say, and I got to give Brian a chance to talk, so apologies, but he's a Supreme Court advocate and I'm just a professor. Congress doesn't have authority to just do what it thinks is a good idea. Can Congress require cause for vetoes? Can Congress require cause for pardons? What's the source of authority? The necessary and proper clause does not say that Congress can modify powers that are granted to the president or the courts. There are particular grants of authority to the president and the courts that can be modified because the Constitution says as much. The Constitution says that Congress can vest the appointment of inferior officers in courts of law. That is to say that they could take away the president's power to nominate those people and give it to the courts to appoint unilaterally. The Constitution says that the Congress can create exceptions to the Supreme Court jurisdiction. It doesn't say that the Congress can create exceptions to the president's executive power or his power to veto or any of those things. So Brian is quite right that there's a century of, I'll say one more thing. Brian's right about a lot of things. Brian is right that there's a century of these restrictions. Brian says we should be humble about overturning that, and I will pose a question to you. The president has been invading foreign nations for 100 years. That's not the original scheme. Are we supposed to make our peace with it because by practice they've acquired this authority to take us to war? President Trump can take us to war with the entire world given the current doctrine of the executive branch. They claim that there's some restriction. There is none, right? The Korean War was not approved by Congress. The executive branch cites that as a basis for its authority to go to war, or to use military force, right? They don't want to use the word war, as if that's going to fool us.
Are we not going to question that because it's, because we have to be humble? We should all be humble. I agree with Brian. But I think the court's going to get this right. Sorry about that, Brian.
No, not at all. In fact, you put on the table, I think, 3 of the things that I was hoping that we would talk about. So let me sort of go, I think, in order and cover the same points. And the first is about the line that I gave, because that is the difficulty of my position, is that I need some line. Because my answer is no, Congress can't restrict the president's ability to remove everybody, but yes, he can restrict some, and so you need some way to tell one from the other. Cy's position has the virtue of simplicity, right? The president has to be able to remove them all, and so there isn't a line drawing problem. I guess, while acknowledging the difficulty of that, I don't think that's unusual in these separation of powers type questions. I mean, we've talked again and again about these very generally worded provisions. Often separation of powers questions turn on questions of degree and on matters of judgment that are informed by history and tradition and constitutional structure. And I think you can do the same thing here. I think there's a reason why at least many of us lawyers have the intuition that Justice Kagan did, which is to say the president, although Congress also has authorities in the foreign affairs space, the president's supposed to serve as the country's sole voice with other countries. He's the one who's supposed to do diplomacy. Congress isn't supposed to do that. And the president can't do that if his mouthpiece, if the person who's supposed to act on his behalf in that sphere isn't someone who has his complete trust and confidence. And so it's logic like that that gets me to the idea that the Constitution says the Secretary of State sits in one bucket, and I have a very different reaction to, say, the chair of the Merit Systems Protection Board, where I just don't think there's the same constitutional argument that the president's duties require him to have complete control. The second thought, if you don't mind me just sort of ticking them off in order, I think Cy's, and I think, although I won't purport to speak for him, this is a sort of broader theme of Cy's scholarship. There's this question about, well, if we agree that removal of executive officers is an executive power, then what business does Congress have regulating it? And a question that I have for Cy is that I'm actually not sure that that's right. I think there are lots of things that only the president can do that Congress can't do for itself, but that Congress can nonetheless regulate. So bringing suits to enforce federal law is a classic example. Lawyers will say, that's quintessentially executive action. Congress can't have any role in that. It can't have congressional employees doing that sort of stuff or anything else that involves the execution of the laws. But we don't have a problem at all if Congress says to the president, here are the circumstances under which you may and may not bring suits to enforce the law. Similarly, appointment of officers. Constitution vests that in the president with the advice and consent of the Senate sometimes. But Congress often says, here are restrictions on who you can appoint. If you're going to appoint a Secretary of Defense, it has to be someone, it can't be someone who is in the military in the last 5 years. If you're going to appoint someone to some of these commissions, you can't have everybody from the same political party. The Solicitor General, my old boss, has to be learned in the law. That one may be difficult to enforce, but it is a requirement in a statute. So there are all sorts of things that Congress does to prescribe the ways in which the president executes the laws, and I hope we can unpack why you see those as on one side and removal restrictions as on the other. And then lastly, just briefly, you mentioned history, and you're of course completely right. My submission is not that because something has been happening for a long time, it must be okay, and we can't inquire into whether it's valid or not valid. My argument instead is that this is an area in particular where practice has been important from the beginning. The Constitution doesn't say anything about removal except for impeachment, which everyone agrees doesn't fully speak to the question. It wasn't mentioned in the ratification debates. It first came up at the decision of 1789 in the first Congress, and there's this amazing, wild diversity of views. I think it's actually really interesting how many different things people thought. Famously, James Madison and Alexander Hamilton both changed their mind on this question, right? So I think it's very, very hard to say that there's a settled, established, original meaning at the time of the framing. Instead, it's a thing that Congress has worked out in practice. And to me, I would extend the line of practice and have it not just stop in 1789, but also continue through later years when different questions got posed and different answers have been given, and would credit those and treat those as part of the same body of evidence as we do the decision of 1789.
Go right ahead.
Brian is so reasonable and so smart. I guess what I would say is Congress is a legislature with limited enumerated powers. It doesn't have a generic grant of legislative power, and no one believes it can just sort of change the Constitution willy-nilly. So to say that the president has a veto and to not give Congress express authority to take away the veto or constrain it leads to the conclusion that Congress can't take away the veto or constrain it. As much as we might like it, we might have a president who's vetoing everything out of spite. Right? We've had such presidents, right, who've issued hundreds of vetoes, not in recent times, but in the distant past. And we might think this is terrible. Why can't Congress do something? And the answer is because there's no authority to do it. The necessary and proper clause is not a grant of authority to say, I think you've misused your powers, or I think it would be better if there was a check on your powers. And so we're going to enact a statute to impose that check upon you. If we're going to think about the first removal constraints, they're actually ones where the Senate insists upon a role in removal, precisely the restriction that Bryan rejects. They impose this restriction on Andrew Johnson. Andrew Johnson is a Southern Democrat. He's soft on the South. It's a unity ticket. That's why he runs with Lincoln. Lincoln gets assassinated. And now we have a Southern president who wants to reintegrate the South very quickly. They then say, you can't fire the Secretary of War unless you get the Senate's consent. Well, that's basically one of the first removal restrictions. And they continue to impose a Senate consent requirement for a long time until it's struck down by Myers, which is a case in the 1930s, some 60 years later after the fact. Well, I mean, I'm not sure why Bryan's opposed to that restriction, right? I don't see why it's so wrong. In fact, my position is, and this is a weird oddity of me, I'm an odd person, I think that Congress can remove people. They just disestablish the office. All these offices are created by Congress. There's no requirement that the Secretary of State have particular functions or that it be called the Secretary of State. They have disestablished offices in the past. They disestablished judicial positions. In 1801, they fired all the circuit court judges by disestablishing them. So of course they can get rid of an officer by disestablishing the office and creating a new one with different authority. So I actually have a slightly different position than Bryan, but I think the president can fire the person as well, and I don't think that Congress can constrain it. So maybe the more people that can fire bureaucrats, the better. But I don't think that Congress just has some generic authority to restrict the president's power to remove. Obviously, Bryan's right that it matters that we've had these removal restrictions for a long time and that the court upheld them for a long time. I will say one other thing that is practical that relates to this, which I did not say. You envision that the people who head up the FTC, the Federal Trade Commission, the Federal Election Commission, the Securities and Exchange Commission, you envision that these people will serve their full terms, which then makes it difficult for the president to assert control over these agencies. But in point of fact, when the president appoints people to these agencies, he's appointing people who do not act independent of the president. Reed Hunt was the chair of the FCC during the Clinton administration. He was Al Gore's right-hand man before he was the chair of the FCC. It was not an independent agency. It worked hand in glove with the White House. So they're not independent agencies in any sense of the term. They're really working with the president. The other thing you need to know is that they don't serve the full 5 years, which means that within a year of coming into office, the president has effective control over all these agencies. And so we're talking about something because I feel passionate about it, but the practical effect of it is very little because this president will control all these agencies through turnover a year or two in his administration. And so what we're talking about is a shift in time, right? There's asynchronous presidential control over these agencies, and I'm just saying it should be synchronous. Joe Biden should not be saddled with Donald Trump's appointments, and Gavin Newsom or Kamala Harris or whoever, Kamala Harris, shouldn't be saddled with Donald Trump's appointees. That's all I'm saying. But the idea that these people, the Fed chair serves a full term, most people don't because it's too lucrative not to go into the private sector after you have regulated that sector.
Let me ask a question for you, Cy, since I think I know Brian's answer, which is, there's been a fair amount of speculation that the Federal Reserve is different from other agencies, and that even if the president can fire the heads of other agencies, they can't fire the Federal Reserve commissioners. What's your own view of that?
You know, when I was, when my kids were younger, we used to watch Barney. And Barney had the song, you are special, you are special. Everyone is special. Everyone is special in his or her own way. That's my recollection. And I used to be able to sing this. The Federal Reserve is special, but is it really special? I think what people are saying is when they say the Federal Reserve is special, they just mean it would be better if politicians weren't involved in the Federal Reserve. And I was taught as an undergrad economist, economics major. I was an economics major, that countries did better if they had an independent central bank. I have no reason to doubt that. I look at the Congress and I think we might be better if fiscal policy was not set by Congress. Are we gonna, we might think, that's kind of the progressive impulse behind a lot of the delegation to these agencies, right? That experts should be doing these things rather than the legislature. I'm not sure that the people running these agencies are experts anymore. I'm not sure they're independent. I'm not sure, maybe the Fed is the lone wolf in this regard. Maybe we can have an amendment if we all agree that the Federal Reserve is different. I will say that the Federal Reserve executes laws. It's not just a monetary policy institution. It actually executes laws vis-a-vis banks in this country. And as I think Michael McConnell said this a long time ago, he's a professor here at the law school, it's not obvious to him, and it's not obvious to me, that the setting of interest rate policy by the Fed is a governmental function at all. If that's what you want to, if you want to have that done by a private institution, I don't think the president has any authority over that. But if you're regulating banks and you're bringing enforcement action against banks, that's just what the executive branch is about. And of course, the Treasury also brings enforcement action against banks. They've just decided to split enforcement of certain bank rules, give some to the Treasury and some to the Fed. It's not obvious to me why that is. I don't even know what the split is, but that's my sense of it. So I like the Fed, I guess. I've been told I have to like it, and so it is special. But I don't, just separate out the interest rate function of the Fed from the law execution, and I don't have an issue with that.
So, Brian, without asking you to sing the Barney song, although you're welcome to do that, you do think the Fed is special, but you also think there are a few other agencies that are special because of, say, the danger of political influence. And you acknowledge that it's hard to draw a sharp line, but could you provide some guidance to a court or anybody here who's trying to draw the line between what's special and what's not?
Yeah, I think it's useful in thinking about how to draw the line to separate out questions of law and questions of policy, because I think from my perspective, I'm inclined to think that the set of offices where the Constitution says the president has to have total control is probably significantly smaller than the set of offices for which it's a good idea to give the president total control. I think in general, it makes sense to have lots of different agencies that are doing things that relate to each other, all pulling in the same direction. I think there's force to Cy's point about accountability and wanting to be able to blame one person. And I've been a lawyer in the Department of Justice and in the White House, and I've seen sort of the value of having the president or someone in the White House be able to coordinate efforts across multiple agencies. And I've been frustrated by independent agencies that weren't doing what we wanted them to do at any particular moment in time. And so I sort of understand that there are good policy reasons to have accountability to the president across a lot of agencies. I think for the legal question, though, I think the one that Justice Kagan, as Cy alluded to, and others have drawn is does the president have to have the authority to remove this person for any reason or no reason at all in order to fulfill the president's own constitutional responsibilities? And I think the answer to that in the foreign affairs realm or in other circumstances where you have officers who are doing things that the Constitution vests the president with discretionary authority to do, there's a good argument that the answer is yes. When you're instead talking about officers who are doing things that Congress didn't have to give the executive branch permission to do at all, right? That's true for many of these other agencies. There didn't have to be a Federal Trade Commission at all. It exists only because Congress decided that we should have one. It exercises all of its authority to do any of the things that it does to protect consumers and enforce the antitrust laws only because Congress has decided that it should. All of those are authorities that the entity has only by virtue of a congressional delegation. And there, as a legal matter, I think there's a much stronger case to be made that Congress can restrict the president's authority to remove.
I was going to ask about, Brian, you brought up the example of election commissions. And so imagine that you think that democracy itself depends on some independence of the election commission from whoever happens to hold office, and that not allowing that would undermine the very institutions of democracy. Would that be, say, an argument you would accept for restriction there?
It's a great question, Deborah. I think obviously you need to have, as they say, free and fair elections and ones that people have confidence in. Our federal system kind of does that already, right? In the sense that the states are the ones running the election, not Donald Trump or not Joe Biden, both for the Congress and for the president. The Federal Election Commission is of recent vintage, right? It didn't exist 100 years ago, and that's because the federal government decided to regulate campaigns for a number of reasons, many of which are good. We can debate that, but that sort of introduced the issue. But I'm not an election law expert. I know a little about it. There are probably other people here. All three of you know more than I do. But it's about contributions and raising funds and that sort of thing more than it is about counting votes. The Federal Election Commission does not hold elections and does not count votes. They're regulating the conduct of campaigns, who can donate, how much they can donate, that sort of thing.
So thank you both for getting us going. Before we turn this over to questions, let's put the polling question back up and see whether any minds were changed. All right. My recollection is that there's a substantial move from yes to no. I didn't count the numbers, but okay. So
It moved in your direction.
Yes to no. No, that went in your direction. You said it was yes to no?
I thought there were.
I think the move was from no to yes. I think it was like 85-ish before.
In any event, a interesting move. So now it's up to you. If you have questions, come to one of the microphones, and we'll take people from the different microphones. Don't be shy. Kaiser? Oh, that's right. Can we put up the attendance? I think all the phones are down, so I think it's time for a question.
I'm Robert. I'm a sophomore studying history and economics. So this is a question for Professor Prakash. I think that it was Russ Vogt who said that the goal of DOGE and kind of the administrative cuts right now is to traumatize bureaucrats. His words, not mine. And so I think there are two worldviews when it comes to like your end goal of trying to eliminate most of the administrative state. There's kind of the shock view where it's like, we do it illiberally and just kind of get rid of everything, make it really traumatic, and really disincentivize anyone from going into, I guess, a future administration. I guess there's maybe a potential for a liberal version of this, maybe, with abundance or some sort of way to do it gradually over time and democratically. Do you see that this rollback of the administrative state can be done democratically, liberally, or will it always be that shock therapy?
I mean, it's an interesting question. We didn't, I mean, the topic is the administrative state, but the question, that we were asked to discuss was far more new. There are other, the topic, it says the administrative state, but we've only been focused on removal. And as many of you know, the administrative state is also issuing rules and regulations that we have to follow upon pain of, jail time. And then it's also engaged in adjudications that, where the judges don't have Article 3 protections of the sort that we think are important, and that's why we have them in our Constitution. So those are other aspects of the administrative state that we just haven't touched upon. I think, Russ Vogt is talking more about the rulemaking ability of the administrative state, and I have views about that, but I haven't talked about them today. I don't want to be I'm sure he's a fine person, but I don't want people to think that I have his view. So I'm not sure precisely what you were getting at. I think maybe you were saying maybe democratically versus what was the other approach? Top down. Yeah, I mean, I think the portions of the Donald Trump administration like to talk in graphic terms, shock therapy and Steve Bannon said of breaking the administrative state. I have to say, when you have, so I mean, I think this isn't the topic for today, but when you basically have the executive branch legislating, which is what you do have in the modern era, then you can expect that whatever you break will be remade in 4 years. He cannot end the administrative state if the next Congress and the next president can rebuild it, or if the next president can rebuild it unilaterally, right? The more power you vest in the executive branch, the more easy it is to undo every single one of Donald Trump's reforms. So the folks who like what the president's doing now are making hay while the sun shines, but there's no permanence to it because Congress is essentially a bystander. It's a giant debating society that isn't able to pass laws and isn't able to force the president to honor those laws once it passes them. So I don't think that we can expect that Governor Newsom or Kamala Harris or whoever will just acquiesce to the destruction of the administrative state. They will rebuild it.
Brian, do you want to add anything?
I think I agree that that's a different and very interesting and important subject, but not one that we've covered today, unfortunately. I guess I will say I'm less sanguine about the ability to rebuild the administrative state. I mean, I think what DOJ has done and others is drive a large number of people out of the government. And that's an enormous loss of institutional capacity and institutional knowledge. I think of former colleagues of mine in the Department of Justice who'd been in the department for 20 or 30 years, who had built up enormous reservoirs of knowledge and expertise representing the United States, who are gone now because they've been fired or asked to leave or otherwise moved out. And I think hopefully, many of those people can be persuaded to come back in a future administration, but I don't think we can take that as a given. And I think, although I agree with Cy that everything that's been done in this administration can, at least as a formal matter, be undone by another president, I think there's been a real loss of institutional capacity already that's going to take an enormous amount of effort to rebuild.
We'll put that issue on next year's agenda.
Hello, thank you all so much for today. I wanted to ask you both about your views on the accountability of presidents. So I'm not a Supreme Court litigator nor a published legal author. I'm just a second-year law student. So in my limited knowledge, when I think of accountability, I think of either the civil law system where if you hurt somebody, the person that gets hurt can be made whole if they can win in court, or the criminal law system where you find some form of justice, or third, some kind of internal organizational policy, like for instance, an employer firing an employee. But when it comes to the President of the United States, because they have immunity from civil lawsuits, and recently with the Trump v. US case, they found that a president, even after their term, cannot go through criminal lawsuits regarding their role as president. And so for me, the only thing that kind of remains is potentially the constitutional policy of impeachment, which then goes to Congress. And so I was curious if that view of accountability is even accurate, if you have something else in mind, or if you actually do buy into this view, what does that say about the current dynamics that you have been talking about today?
So I don't want to speak for Cy, so he should correct me if I'm wrong. I think usually when advocates of the unitary executive talk about accountability, I think they are talking about the idea that the president's the only one, the president and the vice president are the only ones in the executive branch who are democratically elected. And so they're talking about accountability to the people. And the idea, as Cy said, if you don't like immigration policy in the current administration, vote him out. If you didn't like Joe Biden's policy, vote against Joe Biden. I do. I think there's force to that in a lot of places. But I think our system is not one of direct democracy and not one of perfect accountability. And I think sometimes the electoral mechanism of accountability, the same thing that makes the president accountable to the people in some sense, can create some of the concerns, like the short-term pressures that give us reason to think that maybe monetary policy should be independent from the president, or the civil service system should be independent a little bit from the president. There are costs to the electoral form of accountability, and so I think that is one of the reasons why I think, even though insulating some members of the administration from presidential removal might be a decline in that form of democratic accountability in some sense, it's a trade-off that I think may be worth making in some cases.
I mean, I think you're quite accurate to say that the court has built a fortress around the presidency in terms of immunities, both civil and criminal. I personally don't agree with those decisions. I think the other mechanisms in the Constitution are formal and informal. The formal one is impeachment. I think, impeachment is basically a scarecrow, as Jefferson said when he was president. It doesn't serve to constrain the executive branch, given the rise of the party system and the president's role as the party leader. It's just impossible for his co-partisans to vote to convict him. You can get an impeachment. That's easy if you control the House. You just can't get a conviction, and so it tempers the willingness of the House and the Senate to do this, and because they kind of know the outcome, they have to decide to do it even though they know it's not going to function in a particular way. I think part of what the founders are talking about is we know who to blame, right? And not necessarily in an electoral sense. Taking blame for things matters even if you're not up for re-election. I don't think Donald Trump can run again. According to Donald Trump, he's won 3 times. That's one more time than he could run again, right? But he ran again anyway. I don't think he's going to run again. I don't think he can. But it obviously matters to him what his standing is in the country. Because if it's true that if he went to 10% popularity, more Republicans would break from him, right? And so he does have to worry about things getting ascribed to him, rightly or wrongly. And so I think it is relevant that, I think one of the reasons why Joe Biden lost is because of his border policy. And I think if Donald Trump has a low net rating, it's because of some of his immigration policies. People do ascribe these things to the president. And in both those cases, it's appropriate to do so, I think. Certainly Trump, no one doubts that Trump wants to close down the border and deport millions of people. Given what Biden said as a candidate, I think that's fair to ascribe his policy. It's fair to ascribe that to him too. So I meant it in that narrow sense because I don't believe impeachment serves a function, and I agree with you that the criminal and civil stuff has no force to it anymore.
First of all, thank you so much for being here. My name is Vikram Narasimhan. I'm a freshman studying data science. My question is principally to Professor Fletcher, but I'd be curious to hear what Professor Prakash has to say as well. And as someone formerly in the SG's office, and I know you mentioned your dilemma was kind of line drawing, I'm curious what your thoughts are on DOJ independence, both of the ability of the president to fire career officials and to kind of dictate the pace of prosecutions. do you feel that the directive in the Constitution that the president take care that the laws be faithfully executed kind of implicates this? And I'm curious what your thoughts are also on, I know the Supreme Court, I think, touched on this issue a bit in the immunity case. Just curious to hear what you think about that.
Yeah, so it's a great question, and I'll be completely candid. It's one on which I'm struggling right now. Right, so historically, the Attorney General has been removable by the President at will. He has not been one of the officials who's traditionally been protected by this inefficiency, neglect of duty, malfeasance in office standard. But there's been a very strong norm, at least since Watergate, that the President shouldn't be controlling the prosecutorial decisions of the executive branch, because that strikes everybody as problematic. If the president is calling up and telling the attorney general who to prosecute or who not to prosecute. I remember back when I was in law school, it was 2004, 2005, there's a huge scandal because President Bush had fired some U.S. attorneys who were insufficiently aggressive, I think in going after voter fraud or something like that. Massive scandal. It seems so quaint today, right? So I think if you'd asked me this question 3 years ago, I would have said some measure of DOJ independence is really important, but that's a norm that's sort of deeply entrenched in the department that presidents have historically respected in all sorts of informal ways that we could talk about. And so while it's really important to our system that the president not be able to call up and get somebody prosecuted, that's something that's better handled through norms than through this sort of formal removal restriction. I don't know that I've changed my mind about that, but boy, the events of the last couple of months where it strongly suggests that basically exactly that has happened with respect to prosecutions of Jim Comey and Letitia James and others really makes me question the efficacy of the informal post-Watergate norms that I thought were previously sufficient to do this, and to think much harder about sort of which bucket the Attorney General and the Department of Justice fit into if you, like me, thinks that different agencies should yield different answers on this question. So I apologize that's not a definitive answer because it's something legitimately I'm wrestling with.
I mean, I'll quickly say, I think the president has constitutional authority to tell the Department of Justice what to do. And that was an early feature of early presidencies. The president would write to U.S. attorneys and tell them to prosecute people. Now, they thought they were faithfully executing the laws, right? And so, like, there were controversies about whether the persons were properly prosecuted, but I don't doubt the sincerity of those presidents. But I agree that the president shouldn't be doing this. The president doesn't have access to the facts, doesn't know the law in most of these circumstances, and so he shouldn't be making these judgments. And I think if he or she is, and you see that the people they're prosecuting are all enemies, you can draw the inference that it's not really being based on the facts or the law. It's based on the fact that they're enemies. I've never voted for Donald Trump, but I think it's fair to say that some of the prosecutions that he faced when he was a citizen reflected the fact that he was Donald Trump and not some dispassionate analysis of the law. I don't think you have to be a supporter of his to draw that inference, that some of those cases were sketchy. Now, they might have been from the states, right, rather than the federal government, but the problem of politicized prosecutions is real, and it's here to stay. I don't think it goes away once Donald Trump leaves office, because I think both parties are doing it.
Hello, I'm a freshman engineering student. Excuse me. Thank you guys so much for coming. It's really amazing that we can do a class like this. It's really appreciate it. I know there's a lot of constitutional ambiguity around this topic, so I want to ask more of a moral question, specifically talking about that turnover idea Professor Prakash brought up. You both talked about James Madison. One of the justices he actually put into practice was Justice Story, and here's a quick quote from him. He said, "It is utterly impossible not to feel that if this unlimited power of removal does exist, it may be made in the hands of a bold and designing man of high ambition and feeble principles, an instrument of the worst oppression and most vindictive vengeance, It would convert all of the officers of the country into mere tools and creatures of the president. A dependence so servile on one individual would deter men of high and honorable minds from engaging in the public service." So I want to focus on that last sentence. What do you think about the type of people that may want to engage in politics if they know that this administrative executive can fire anyone at will at any time without even having the option of turnover if they're forced out of their position rather than resigning from it willingly. Thank you.
This is incredible, isn't it? He's found this quote from James Story, right? Or Justice Story, sorry. And I think the context there is Justice Story doesn't like Andrew Jackson. That's the context. Madison himself doesn't like Andrew Jackson. And they don't like Andrew Jackson's removals. They don't like the new people coming into town, right? And there's a lot of turnover with Andrew Jackson. The irony is there's a lot of turnover with Thomas Jefferson. James Madison was part of that administration. Thomas Jefferson tried to hide the number of removals he was making because he had the view that there should be some people of my party in the government. It shouldn't all be Federalists, which makes a lot of sense because a lot of the Federalists were opposed to his administration and opposed to his policies and would continue to oppose his policies. So there was a lot of removals by Jefferson. He just did a good job of hiding them. I don't think Andrew Jackson cared, and so he was just more, aggressive in removing people. I think, but let me put it this way. You're right. If you can tell people you'll have 30 years in the office, call them professors, they might make different investments, right? If you tell people, if you hire someone as a professor and say you could be fired at any time, they're going to invest less in being a professor, right? For obvious reasons. But there's a trade-off, right? You're going to have more investment if you have life tenure, but you're going to have more independence from the people, right? And part of the vision that Brian's defending, and I think he admitted this, is a bureaucracy that is sublimely independent of you and me because they know better than you or I do about what ought to be done. And I admit that, there are people that know better than you or I do. It's really hard to figure out who they are, right? And I don't think it's the people running these agencies because they just seem like you or me, right? They're aides to Senator McConnell or aides to Senator Schumer or aides to the president. They're not angels dropped from heaven. They're, they may know a little bit more about something than you or I do, but they're not. It's not Albert Einstein who's running the Federal Election Commission, right? Or think of the most moral person you know, right? Abraham Lincoln or Mahatma Gandhi or Dr. King, right? It's not those people. It's fine people, but they're not different than the people that are running the State Department or the Department of Defense. Anyway, I've said too much, sorry.
No. So you asked specifically about what does this do to people's incentives to enter into government service, and I can imagine it mattering some. The presidents or the heads of the Federal Reserve have been pretty distinguished economists, and if suddenly they were to wake up and find out that actually you're going to be removable, at will by the president instead of having a for-cause protection, I would certainly think twice about taking the job under those circumstances. But I think, honestly, most of the heads of most agencies have been removable at will by the president for a long time. And even if the head of the Federal Trade Commission, the Federal Reserve, those would still be fancy, desirable positions. I don't worry that much about the ability to attract people into them. The place where this does worry me, though, is an implication of the issue that we're talking about today that's not directly at issue, but that I do think is worth touching on. Which is, we've been talking about the very senior people at the tops of departments. A really strong version of the unitary executive, and I'm not saying this is Cy's view, I don't know what his view is, but would say this goes all the way down. If all the executive power belongs to the president, then this removal stuff doesn't stop with the Secretary of State. It goes down to everybody else in the Department of State who's executing the laws. That would be, I think, an even bigger change because it would really upset this idea of a civil service system where people can't be fired for political reasons and have a certain amount of tenure almost in their jobs. And I do think that if that went away, you would change the calculus of people who go into the civil service because you get paid a lot less when you work for the federal government than if you work in the private sector often. And people who choose to make that trade-off do it for all sorts of reasons, including a desire to serve and to learn things. But one of the things that makes those jobs attractive is that they're jobs that you can have for a long time. And if instead they became jobs where you got cleaned out, every time there was a change in presidential administration, I worry a lot more about the caliber of people who we would attract and retain into the lower levels of government.
So under your theory, can the president fire a low-level civil servant?
So, I think the law on this is less clear and less developed. I believe the president can remove all officers of the United States. Under the U.S. constitutional system, we have officers and we have employees. The Constitution doesn't mention the word employee, but we've long drawn this distinction. Certainly in the military, we have, commissioned officers and enlisted personnel that aren't commissioned. And the Supreme Court has decided that officers are people that exercise significant government authority. And I think that's a fine line to hew to in terms of removal. This was also Madison's position, right? That it's not just the department heads, it's the tax collector, it's the senior tax collector, the port collector, the U.S. attorney as well that the president gets to remove. And of course, there's a certain, Brian talked about the Secretary of Defense. Well, what about a general? What about, a high-ranking military officer? What about an ambassador, right? And so Brian's argument might go below these positions as well because, a general can violate the law just as much as a president can or someone else or a Secretary of Defense. And the U.S. attorney could be misconstruing federal statutes, right? And so I'm not sure, might differ as to where we would draw the line, but I'm not sure Brian's position is only that the president can remove the topmost level official. He hasn't said, but my position is that the president gets to remove officers, those who exercise significant government authority, which is admittedly in a very amorphous test. But it's the test that the court's using now to figure out the distinction between officers and employees.
I'm Adam. I'm a freshman, and I'm directing my question to you, Professor Prakash. So you've invoked, in support of your argument, James Madison and George Washington, in support of sort of like the energetic executive. But I wanted to ask you where their views presented in Madison's Fed 10 and George Washington's farewell address, arguing for, not a concentrated base of political powers, many factions competing against each other as a way to, stop concentrated political power. They certainly didn't imagine that we would have a two-party state. So when we have a situation where, all three branches of government, the Supreme Court, Congress, and the presidency are controlled by an entity like the Republican Party, and the Supreme Court and Congress could be argued are subservient to the president, and the bureaucracy, certain parts of the bureaucracy remain the last part where it's sort of nonpartisan. How do you reconcile that with your argument?
That's a great question. I think it actually ties in with what Brian was saying. There's sort of changed circumstances. And of course, I think that's a powerful argument for wanting a different system. But of course, there's all kinds of changed circumstances, right? Maybe we shouldn't have a First Amendment anymore. Maybe we shouldn't have a rule against general warrants anymore. Maybe we should have less protections for free exercise, right? This argument from changed circumstances can't only apply to the executive. It's got to apply to every single constitutional question. And once you do that, well, then you realize everything is up for grabs, and there are no fixed points, right? It's all a question of reimagining things in light of our current situation, which is tempting, but I don't believe that the Constitution is meant to be flexible in that sense. If it were, it would just say, do good things. Here are our ideas of good things, but you do you. And you figure out what you think is a good idea, and as long as you follow what you think is a good idea, you are following the Constitution. So I don't think that's the Constitution. I don't see the point of that Constitution if we were to codify that. But you're absolutely right that there's a tension between my criticism of other aspects of the executive and this, in the sense that I'm saying the president should have more power here, even as I'm saying he should have less elsewhere. But I see that as consistency because it's hewing to my vision of the original Constitution,
one where the president could control law execution but not take us to war. The question for other people is, well, why do you think the president, should be able to do less with respect to law execution but take us to war? Like, why is that optimal, or why is that consistent with the Constitution if we're going to be looking at practice? But it's a very nice question. Thank you.
So we have two people with last questions of the day. Let me suggest, just in the interest of time, that each of you state the question, and then our guests will answer them.
Okay. So thank you so much for coming. I wanted to ask. So originally, like as you said, Brian, there was this theorem that that departments can be added or removed based on the reality of and needs of the changing world. Oh, sorry. I'm a student journalist here, but the addition of DOGE and the removal of the DOE was a pretty significant step, and it kind of marked a point. So what precedent do you think this sets from the future in terms of adding or removing departments?
And then the other question.
Good afternoon. I'm a freshman studying political science and also in Navy ROTC. And I was actually wondering about, we talked about the restrictions of certain departments, the presidential ability to remove. And what was mentioned, the Interstate Commerce Commission creation in 1887, and the restrictions were inefficiency, neglect of duty, or malfeasance in office. And I was wondering how you'd be able to word it that the president has restrictions on how to remove, because I feel as though, how can you make it not broad enough to say, oh, they were inefficient for some arbitrary reason that the president thought?
So I'm happy to start, and I'll try to be brief. So on the first question, sort of what precedent will be set by the current administration's effort to substantially curtail or wind down departments, I think the jury is out on that. I think in part because those issues are still working their way through the courts. We saw a lot of challenges to the defunding of a large chunk of the Department of Education and to other similar initiatives. I think there have been a lot of skirmishing on initial procedural issues. The Supreme Court has not yet weighed in or given us a sense of where it's going to weigh in terms of whether those things are lawful or not lawful. I think, as my comments suggested, I think Congress decides whether or not we should have departments, and Congress decides at what rate they should be funded. So my hope is that ultimately, when all of the dust settles, that principle will be reaffirmed, and that will be the precedent that we take from this. But I think we don't know the answer yet. And then just briefly to the second question, I think you put your finger on a great question, which is, well, if we're going to have these removal standards, what do they mean and how are we going to enforce them? And I think an interesting feature of our sort of constitutional history is that during the 100 or so years when we had them, there was not a lot of fighting about them because they set the sort of terms on which the president would interact with independent agencies, and presidents understood that they had less authority over those agencies. That is, as Sai alluded to earlier, a function of a lot of different things, not just removal restrictions, but also appointments and budgets and 100 other different things that affect the president's power over different parts of the government. But I think the lesson that I take from that is that the importance of these removal restrictions is a little bit less the fine details of what does inefficiency, neglect of duty, or malfeasance in office mean, and a little bit more the norm that has prevailed for a century or so, that there are some agencies as to whom the president has to take a somewhat more hands-off attitude. And admittedly, I'm not giving that a lot of definition, but I think it's the sort of thing that's been developed in practice and through a lot of norms in the way that presidents have long dealt with independent agencies different than other agencies.
Brian's absolutely right. I think that language hasn't been probed because most presidents see that. Most presidents are told by their aides, you really can't get involved with these agencies because they're independent. And then there's really no supervision of them, I think, for the most part, by the executive branch, because they're sort of, if you tell the president he or she can't do something, they tend to sort of understand that I guess they can't do it. And so these agencies have been, I think, until recently, rather independent. Until I think maybe the Clinton or Reagan administration, they were fairly independent, and no one paid attention to the removal standards. And so I think there was only 2 removals over the course of 80 or maybe now 100 years under these standards. One of them wasn't contested, and so there was no court case. The other, they actually held an internal adjudication within the executive branch, found inefficiency, neglect of duty, or malfeasance, and there was no court case. So the court cases that have discussed this have all discussed it in the abstract, where there's no actual allegation of inefficiency, neglect, or malfeasance, except for this Federal Reserve case, where I think it's the first time that someone has been removed under this standard and it's going to be adjudicated.
So before thanking our 2 guests, let me remind you that unusually there's a double header in this auditorium, because I think at 6:30 Justice Breyer is going to be talking. So come back at 6:30. So but thank you both, first of all, for giving everybody a spectator's guide to what's the litigation in the Supreme Court, but then with the questions and your response to the questions afterwards, a much broader education on matters involving the U.S. Constitution and Congress and the executive. So thank you very, very much.